I don't have a political background as a legislator, and therefore I may be having a shortfall or a shortcoming to do things which many others would do. But I am proud that what I do is for the good of the people and the good of Goa. People have faith in me, my voters trusted me, and they elected me to the house. You know that आमकां election रात्री आमी assembly वयतात तेन्ना लोकां भावार्थ आसता आमी कितें कोतले आमी कितें सांगतले आनी बरे गोश्ट मांडून आमी रेस कोतले सगळ्यांचे हिशोब आमकां धाडलो ना थिंगा एक ड्रामा करपाक एक नाटक करपाक or फोटी मारपाक. People, not only my constituency and every constituent of every other MLA is watching his MLA perform. The Goan electorate and the Goan citizen, people of Goa are watching. The nation watches, and even Goans overseas and even friends and others who are not even Indian nationals will be watching what we do. So we have a higher sense of responsibility when we step in the August House to put facts right. If you want to tell law, you should tell law correctly. You should not mislead the House, and you should be truthful and honest. Now on this, why did Wenzi Viegas get upset? Wenzi Viegas, and I start the video, he said the request for amendments of the code is by way of Article 652. And Imagi Mulla, 1526 2000 शेकड्याचो कोड हे जेचो अमेंडमेंट हाडटो जाल्यार आतां तो आमी हाडून सोदताय. It has to be brought by means of Article 652 of the code, which has not been done in the right manner. आणि हे ते हांव कोडात हे दाखयलां आमी वाजयलां. आयज सीएमान म्हाका विचारलां what is the position on Article 652? आणि तेन्ना हांव उबो रावला. मुगे चान्स नाशिल्लो उलोवपाक, पूण हांव उबो रावला कित्याक म्हाका विचारलें म्हणून. आनी हांवें कायदो तो कितोय सांगला. हांवें सांगला 652 does not come in the way of the House making an amendment. हांवें एडिशनल आनी कितें सांगला. थोडे लोकांक हांवें म्हणलें ना तेका, पूण तो कितें समजोवन तो हांव नेना, कितें आयकलो ना हांव नेना. हांवें म्हणलां थोड्या लोकांक मनान आसा की कोण कायदो हाडलो तो ते लोकांनी ते सरकारांनी कायदो अमेंड करपाचो. आनी हांवें सांगला फुडें थोड्या लोकांक मनान आहा की पुर्तुगेज सरकारान हाडले तो पुर्तुगाल आसपा पडटलो अमेंडमेंट करपाक. तेजेर आरोप केला, तेजेर कांय म्हणना. पूण हांवें आर्टिकल 652 तेजेर करेक्ट इंटरप्रिटेशन दिलें देखून तो बेजार जालो. आता कित्याक बेजार जालो? थिंग कांय म्हणना ऑन द फ्लोर ऑफ द हावस जाप काडना तेणें. कित्याक हांव सांगता म्हाका दिसता तेगे मनान कांय नाशिल्लें, पूण तेगे आसात फाटल्यान बॅक बेंचर ते तेंको जायना चोवपाक दुसऱ्यांचे सक्सेस. तेंगे मनान अजून आहात ते ओल्ड रेजीम तकलेन आहा. आनी ते हांव खरें सांगता, हांव कोमुनिदाद कितले कोमुनिदादाचे हांव शेअर होल्डर. मडगांव कोमुनिदाद आय एम मेजर शेअर होल्डर. वी हॅव सो मेनी अदर कोमुनिदाद शेअर्स. I am definitely interested in the welfare of the Comunidades. I am not anti-Comunidad. I am not a land grabber. I am not a Comunidad land grabber. So I will never do anything in the interest of the Comunidad. But you must remember, what is Article 652? And what's that? Copy pasun data. Every 5 years in the city of Penjim, on the 2nd of January, a meeting shall be held of the delegates of all the Comunidades to deal with the matters of general interest to them, to foster its progress and propose to the Governor General some measures in this connection. That means, tumge kite problems ata, तेजे measures कित आहा ते करपाक सरकारा सांग. So that means they will tell administrator file process ko respond ko. This is procedural matters. Inga kaina that this is for amendment of the code. There is nothing which says they shall be consulted or objections invited before amendment of a code. Please understand, a legislature, whether it's the central government or whether it's the state government, can legislate without even asking public opinion. तुम्ही पळयला आसतले बिल्स आहात ते आमक सकाळी बिल दितात सायन्सा पास करतात. लास्ट टाइम आम ऑब्जेक्शन दिलो देखून 2 दीस पयलीं आमकां दिले आमकां म्हण स्टाईल लोकांक पासून बिल कळना. आम फकत डिबेट चलत तेन्ना डिस्कशन आम बेगीन वाचतात ते कितें तें बिल तें आनी मागीर आम उबे रावतात ओपोज करपाक. सो इफ द गवर्नमेंट, एनी गवर्नमेंट can do this, remember this is statute law. When it is subordinate legislation like rules, the statute may say by previous publication, like you are building regulations, that has to be done, amendment has to be done by previous publication. Objections invited and hearing the objections and then considering them. But when it is statute amendment or statute enactment, inga konache prior consent naka, unless there may be a constitutional mandate, but otherwise there is none. So Code of Comunidades is not a subordinate legislation, it is a statute. So there is nobody's permission required. If Wenzi Viegas, who wanted to show the House that this is the law and he has the backing of all those who have given him, I am going to give you a judgment of our High Court. This is in writ petition number 265 of 2015. Tumkam copy dita. It was filed by 7 Gaunkars of Serula Comunidad. These 7 Gaunkars, and the judgment was passed on 1st February 2022. Paragraph 2 asato, the petitioners who claim to be Gaunkars, Joneros, Jonkars and legitimate components of the Comunidad of Serula have instituted this petition seeking the following reliefs. A. That this Honorable Court be pleased to call upon the respondent number 1 to produce before it the records pertaining to the various amendments moved before the Code of Comunidades, including the statements of objects and reasons, and record of deliberations, etc., and on perusing the same be pleased to issue an appropriate writ order or direction, thereby quashing and striking down all amendments affected to the Code of Comunidades listed in Annexure D. What's now? I am going directly to Para 3. Para 5. The pleadings in this writ petition in context of challenge to the validity of the various legislative amendments to the Code of Comunidades are also quite sketchy. The petitioners have not pleaded in precise terms how, according to them, the several amendments they have challenged contravene Part 3. Part 3 kite fundamental rights, or are beyond legislative competence of the state, means state government has no power. In the absence of proper pleadings, we do not think it will be appropriate for us to entertain the challenge to the constitutional validity of several amendments to the code. Para 6 now. So and so, however, refer to the provisions of Article 652, also kind of the Code of Comunidades, which reads as follows. Now go to Para 7. So and so submits that for the last several years, there has been no compliance with the provisions of Article 652 of the Code of Comunidades. Since the meeting of the delegates of the Comunidades to deal with the matters of general interest to them to foster its progress and propose to the Governor General some measures in this connection has not at all been held. He submits that the various amendments to the Code of Comunidades should have been made only after such a meeting was convened and held, so that the delegates of all the Comunidades could have offered their viewpoints and inputs on those vital matters affecting the governance of Comunidades. Mr. So-and-so submitted that since this was not done, the amendments to the Code of Comunidades are required to be struck down. At the next paragraph, paragraph 9 was. although we agree with Mr. So-and-so that the provisions of Article 652 of the Code of Comunidades are required to be implemented, we are not prepared to strike down the various legislative amendments to the Code of Comunidades simply because such amendments or the proposed amendments were not considered by the delegates in the meeting that was required to be held in terms of Article 652 of the Code of Comunidades. According to us, that by itself would not be a ground to strike down the legislative measures in the absence of any proper pleadings on how these legislative measures contravene Part 3 of the Constitution or are otherwise beyond the legislative competence of the state. On such a ground, therefore, we cannot strike down the legislative measures. हे आता हायकोर्टान जजमेंट 2022 आणला. तो कायदो सांगता. कायदो आसा तेन्ना तो फ्लोर द हाउस कित्याक फोट मारता. Do we elect legislators who will come to the floor of the house? It's an august floor of the house and make false statements completely wrong, and then you get angry because I tell that this is the correct position of law. You are upset with me and making this thing. You say sorry. You say sorry to the house and you can say sorry to me. I don't even care if you don't say sorry. Apologize to the house for making false statements. Don't try to take umbrage on wrong statements, false statements and false legal propositions which you are saying in the house. Laws the loka, Islam dara daldamun, assembling, photo mark, and Wayland drama korpa, natok korpa bay. It's very sad. And is it only with an intention of trying to portray Congress in a bad light? You make false statements and try to say that only your party is there to save Goa and save the nation? Stop it, I think. There's a time and limit where you can play your drama. There's a time and limit where people can tolerate you. And I think that if you have right, I will say sorry. But when you are wrong, I think you tell the whole world what you are doing is completely false. I also pointed out, that about this amendment, that the government of Goa has the power to amend the code. Why did I say this? Because this is often debated. I didn't say that when Z had said it. I said there are people who believe. And I didn't accuse him, but he suddenly said, I Sanglamun code amendment I think he was not understanding, he was not listening to what I was saying. But what exactly you can hear the recording. I said there are some people who have this belief, and now I will tell you, there is a judgment, which I said I had argued the case and I had won it. Tum kya dastalo, ek very famous gentleman ashilo, Shikali Rautalo, J.J. Rodriguez Mulalo. He was a very strong proponent of Comunidades, strong fighter, very strong fighter, honest man, very good man, and he fought for Comunidades. He filed a petition in his name and as attorney, if I'm not mistaken, of Comunidades or Shikali, this way back in 1996. He filed a petition and his lawyer was Senior Advocate Joachim Dias, First Advocate General of Goa. I was Additional Government Advocate at that time. I opposed that petition. Now please see that petition. The judgment is there. It is by a division bench of Justice Patankar and Justice Bhatta. Date is 11 April 96. And please look on top. Sri J. Dias, Senior Advocate, and I am there as an Additional Government Advocate. Please look at paragraph 2. On 12 December 95, Respondent number 1 Administrator issued notice to the petitioner in view of Article 443 read with Article 125(1) of the Code of Comunidades, calling upon it to pay outstanding dues towards their Rama, towards staff salaries and maintenance office of rupees 48 lakhs 80,000 and so and so for 5 years. This notice is challenged on the ground that there was no legislative competence with the state government to enact the Goa Legislative Diploma 2070 dated so and so, and that the said notice and the demand to the petitioner Comunidades is illegal and invalid. The main plank of the learned counsel for the petitioner's argument is that such legislation relating to Comunidades can only be by Parliament under residuary entry 97 of List 1, Union List of 7th Schedule of the Constitution. While it is the case of the respondents in the affidavit, that affidavit I had drafted, sworn by Angelica Rodriguez, she is the mother of Sanjit Rodriguez, by the way, Under Secretary Revenue dated 2nd April 1996 that the state can enact in view of entry 18 read with entry 32 of list 2 state list for the 7th schedule of the 7th schedule. Now please go to the last page of that. I won't read the whole judgment. The last page. Just see somewhere down. Therefore, just a last sentence before paragraph 14 starts. Therefore, in our opinion, this legislation is valid and the state was competent to enact it in view of entry 18 read with entry 32 of list 2 state list of 7th schedule of the Constitution of India. Therefore, we reject this petition. So I have not only law, I have judgments to back it. I know what I am saying on the floor of the House. I won't mislead. If we have a government which is going to pass a law, they have all the numbers. They have 33, we are just 7. They don't even require. They will listen to us and they'll do what they want. If we stand up and we tell the government, you have seen that clause by clause, the Comunidades law was explained by me, opposed by me on the grounds how it destroys the independence of the Comunidades. I have shown that you should not keep elected people forever. I have shown how that on one complaint you can suspend an elected managing committee. You are not bringing substitute, but you are trying to appoint your man in the committee. I have also shown other provisions which are going to detrimentally affect. No one did that exercise, I am the only one who did it. If I wanted, I could have remained quiet. And when it came to passing of the bill, I was there with all the other opposition members on the floor, on the well of the House to oppose that amendment. If I wanted to, I could have walked up. I could have sat down. I could have said it's not there. I didn't. Even though the government tried to placate by saying that they're accepting this suggestion, and the revenue minister said that I will bring an amendment in the next session of the House. We were not satisfied with that and we went to the floor of the well of the House. So you can understand that there was nothing which we did to play ball with the government. As far as the agricultural bill is concerned, I am the one again, clause by clause, I am dakoila. On agriculturist म्हणून लोका दाखयताले ते गोंयकारा benefit जातले म्हणून. I dakoila agriculturist can be anybody who can come from any part of India who is cultivating even the garden at the back of his house, he becomes agriculturist. I have even said that is what is agriculture. I have explained. I have explained that agriculture includes building farmhouses. I brought provisions of the Land Revenue Code and showed that. So I expressed my apprehension that we will have farmhouse culture here in Goa, and I was very clear about it. That was not amended. I also opposed when it came for division. I stood with the opposition. If the Chief Minister asks for suggestions, if the government asks for suggestions from opposition, and the opposition gives the suggestions, and the government accepts it, I think it should be recognized as a victory for the opposition. One should never think, I did not take it as my personal victory. According to me, it's a victory for the opposition. Sadly, I think that is being torn apart to try to show I'm in league with the government. If I want to do settings, I won't go to the minister's cabin like some do there. Probably when he does, he'll have to answer it in the lunch break and do some settings there. And come back, say one thing and do another thing. I won't do these things. But whoever does it will have to stand up and face the music when the time comes. I have stood for what I have supported, and if my suggestions have been accepted, I think it's a great victory for us in the opposition and especially the Congress party, which has been able to put forward apprehensions, fears, and whatever the people think about it. Opposition is not meant only for standing on roads, having processions, dharnas, rasta roko, or making dramas in the house. Opposition is also required to give constructive suggestions. I have said that on my day of my election result, that I will be constructive opposition. I will not want to simply stand up and shout and not be able to support what I cannot. And I think this is an underlying philosophy of the Congress party, that the Congress party stands with the people. The Congress party will always support the cause of the people, not only everyday lives, but even the smallest of the smallest. Congress will touch the hearts and minds of everyone and will make sure that Goa is protected, Goa is not finished, and Goa is not sold off. Thank you.
You also said that you should have, the bill should have put for the House committee, and then you should have given the suggestion.
If the government accepts a suggestion on the floor of the House, do you call it a demand that I still want to send to House committee?
Select committee.
Select committee.
According to you, what is the bill exactly? Good or bad?
See, as far as the Comunidades is concerned, when you are trying to usurp the powers of the Comunidades, I can't agree with it. As far as that agricultural bill is concerned, you are going to allow farmhouses to come. Therefore, it can't be. It will be allowing a license to allow them to come.
Then what is the reason for that Cool Munka Association to oppose it to Tandi, saying that it is danger?
See, there are so many views I have been reading across newspapers and maybe some channels which I got time to see. They talk about agriculture, making agriculture wider than paddy field, because in this act of agriculture it talks only of paddy field. So they want to say wherever is agriculture it will be paddy field. You must know some history about the Agricultural Tenancy Act. The Agricultural Tenancy Act was actually meant to protect cultivators of fields. Subsequently, somewhere in 1975, Agricultural Tenancy Act was amended to bring even coconut and cashew plantations inside. That is not agriculture, because it was horticulture. So that was also brought in, and there was tenancy also included. So all those lands also got. But now, if you look at this legislation, if you say that, see this is a very funny thing. This land prohibits you from converting a paddy field, from selling a paddy field to a non-agricultural post. It does not stop you from converting to build a, because farmhouse, I told you, is agriculture. You don't require permission to convert to a farmhouse. You have a right to build a farmhouse in a agricultural land. One of the types of agricultural land is a paddy field. Now, if we accept the suggestion of the Mulu Goenkas or whoever I have said, bring others inside it, I will tell you what could be the danger. According to me, this bill is going to give a certificate and a license to allow paddy fields to become farmhouses. If you bring more land, that will be an open charter to give all those lands also for putting farmhouses. You understand what I am saying?
There was also one point which Vijay Sardasa had mentioned, saying that when you say non-agricultural, why is it not mentioned as non-grown?
And that's what I said, no. That was my first attack, because that's the first definition. Who's an agriculturist? I pointed out in my first opening when I start speaking about that bill, the first definition is agriculture. I said the agriculturists can be anyone, not a Goan. Agriculturists can be anybody from any place of India. I said that. You understand? The perception which was sought to be given was a Goenkara protect Muslim. This is a bill to protect and for giving Goans. It was not. I don't see it.
How would you react on Valmiki's message against him?
Who Valmiki? The one who wanted to save Ajmal Kasab?
So when this Comunidades bill was put to voting of the House, right?
Yes.
Who stayed walk out from the voting?
I didn't see it. I went to the well of the house.
So your number was reduced to 6.
I honestly didn't see. Maybe you could see the video and you can see who's not there. But I was in the well of the house. Thank you.
Thank you.